Okay, I'm going to go ahead and get started. I wanted to welcome everyone to our Bioethics Grand Round series here at the Elson S. Floyd College of Medicine at Washington State University. This is the kickoff to our third year of quarterly Bioethics Grand Rounds, and we're very lucky today to have a very eminent speaker that I'll say a little bit more about in just a few minutes. If you could give me the next slide. I wanted to say that our Bioethics Grand Round series is sponsored by the Certificate Program in Medical Ethics here at the Elson S. Floyd College of Medicine at Washington State University. Our certificate in medical ethics is offered in collaboration with Kaiser Permanente, Northern California's regional ethics program. For those of you who are interested in a bioethics or medical ethics certificate program, and especially if you are a practicing healthcare professional or sit on a healthcare ethics committee, I invite you to follow this link that you see on your screen to find out more about our certificate program in medical ethics. I also wanted to say that there's a link here at the bottom that goes to some of our past grand rounds. As I've said, this is the first in our third year, so we've had a number of grand rounds in the past, and we invite you to follow this link. Those past grand rounds do continue to exist on YouTube, so follow that link at the bottom to our past grand rounds. Next slide, please. I also wanted to invite those of you who are sitting on a healthcare ethics committee or have been involved in any capacity with a clinical ethics consultation service at your home institution to consider whether or not you have a story about the potential value of clinical ethics consultation, if you have a story about how it might have helped in a particular case, whether you were the provider, whether you were a provider where the family benefited, if you were a family member, if you were part of the ethics consultation service. Think about submitting your story to the email provided here. We are collecting stories for publication in the journal Narrative, Inquiry, and Bioethics that we hope can demonstrate the role that clinical ethics consultation plays in the clinical setting, in the practice and delivery of clinical care. So please do consider submitting your story to that. Next slide, please. I also wanted to say that our next Bioethics Grand Rounds will be held on May 31st. We have Laura Guidry-Grimes and Amaya Sabatello will be speaking on the topic of disability, inclusion, and access in clinical medicine and biomedical research. That should also be a very interesting Bioethics Grand Rounds, and I invite everyone to register for that as soon as the registration link becomes available. If you are registered for this, I believe we will send you out a notice when that registration becomes available, and you can attend that as well. Also, spread the word to your colleagues if they would find this interesting to come and hear that talk as well. Next slide, please. So today we are very fortunate to have Professor Nina Varsava to speak on the topic of precedents, reliance interest, and the Dobbs decision. Nina is an assistant professor in the School of Law at the University of Wisconsin-Madison, and she works on issues of legal procedure, precedent, ethics, and jurisprudence. Nina has a JD from Yale Law School and a PhD from Stanford. She'll be speaking on this topic because I believe it's a very important topic. The Dobbs decision is one that represents a significant change in how the Constitution is viewed and the role that the Supreme Court plays in U.S. society. While Dobbs obviously changed the understanding of how privacy rights are interpreted, maintaining that the right to abortion as read into the Constitution as a privacy right in both Roe versus Wade and Planned Parenthood v. Casey does not exist. The implications of Dobbs goes well beyond this specific debate. It goes also to one that I personally feel has been neglected by both advocates and opponents of abortion rights. And this is one of the stability and predictability of fundamental rights in U.S. society. Unlike policies that are set by congressional representatives, the Constitution is supposed to enumerate a societal structure that is more stable and lasting than political popularity at any given time. This is why, for example, we appoint Supreme Court justices to lifetime terms, that is to immunize them, so to speak, from political pressure. And it's also why constitutional amendments are so much more difficult to pass than other laws, regulations, and policies. In overturning the constitutional interpretation of privacy that has been accepted as the law of the land for nearly 50 years, and which had been upheld 20 years after its original ruling, Dobbs represents a potential change in the very nature of how we understand the role of the Supreme Court in this political context. This issue, I believe, is one that deserves as much careful attention as the issue of whether a privacy or a right to privacy is embedded within the Constitution per se. Professor Varsava has done this very careful thinking. And the basic ideas we're about to hear about here today are also about to be forthcoming in an article that she has in the Harvard Law Review. So we're very fortunate to have access to very cutting-edge thinking on this important emerging topic. With that said, I want to turn the floor over to Professor Varsava to hear her thoughts on this important issue.
Okay, thanks very much, Dr. May. I'm going to share my screen now. Okay, you should be seeing my slides. Hopefully that's the case. So I'm happy to have the chance to participate in Washington State University's Bioethics Grand Rounds and to share some of my thoughts on Precedent, Reliance Interests, and the Dobbs decision. This is my plan for the talk. I'm going to speak for about 30 minutes. I'll start with an introduction, very brief introduction to stare decisis and the reason for having it. I'll then introduce the Dobbs decision as a meta-precedent or a precedent about precedent. And then third, I'll turn to the matter of reliance interests and the Dobbs decision. I'll explain the court's reasoning for dismissing all reliance interests on Roe and the related abortion precedents. I'll then discuss the issue of concrete or tangible reliance versus intangible reliance. First, discussing possible ways that people have relied on Roe in concrete ways, and then introducing the notion of intangible reliance and exploring whether people have also relied on the abortion precedents in this more intangible way. Okay. And I want to note also, as Dr. May already did, but this talk is based on an article that I have forthcoming in the Harvard Law Review later this year, and the latest draft is available publicly on SSRN. So you are welcome to access it here or contact me directly if you have any issues doing so and you'd like to see it before it's published. Okay, so stare decisis refers to the requirement on judges to treat like cases alike or not to unsettle settled points of law. It requires courts to treat judicial decisions as authoritative sources of law. And because we have a system of stare decisis, another word for it is a system of precedent, that means that judicial decisions are themselves precedents. They're sources of law. Okay, so why have a system of stare decisis in the first place? So a system of stare decisis provides a stable framework for us to organize our lives and engage in long-term planning. And one of the reasons for having a system of stare decisis in the first place is so that people can form reliable expectations about their future legal rights and duties. And when people can form such expectations, they can more confidently and clearly imagine their futures, form reliable understandings about their place in society, and make and execute plans. The deeper values that all this is meant to serve include autonomy and agency, self-determination, and dignity. The idea here is that we can lead more autonomous lives and exercise our agency more effectively when we're able to form stable expectations about our legal future. I think that key to exercising autonomy is the ability to exercise meaningful control in the present over our futures. And knowing what our legal rights and duties will look like in the future helps us to exercise that kind of control. So what's wrong then with overturning precedent? So I want to note at the outset that nothing I say here should be understood to mean that I think that courts should never overturn precedent. The Supreme Court has long had a practice of sometimes overturning its precedent, given that some conditions are met. So sometimes there's good reason to overturn precedent, but precedent should and typically has represented a strong barrier or obstacle to a change in the law. So what's wrong with overturning precedent, or what are the possible harms or costs? First, when courts overturn precedent, they risk undermining or sacrificing the values like autonomy and self-government that I mentioned, that stare decisis is meant to serve. And second, once we have a system of precedent in place, which we of course do in the United States, courts are responsible for people's reliance because they effectively induce it. So the idea is that courts proclaim a commitment to precedent, as the Supreme Court has again and again, and people reasonably respond by relying on precedent. So when a court overrules a case that people have relied on, it can cause unfair surprise. And it's unfair because the court itself encouraged people to rely on their decisions. And so the judges or the court as an institution is accordingly responsible for people's reliance. So it makes sense then that when a court like the US Supreme Court deliberates about whether to overrule some precedent, it would consider whether there's reliance at stake. Reliance interests are a factor that the Supreme Court and other courts often cite as something to take into account when considering whether to overrule a case. So they ask, to what extent did people rely on the previous decision to order their lives? What kind of reliance would we be upsetting if we were to overturn the case? So upsetting reliance interests is a relevant harm for the court to consider. And where reliance interests exist, those would typically weigh against overruling the case, although they might not be dispositive. So sometimes there may be weighty reasons on the side of overruling that outweigh any reliance interests that would be upset. Okay, so in the case of Casey v. Planned Parenthood from the 80s, the court was asked to overrule Roe. Many legal experts at that time thought that the court would overrule Roe. In Casey, the court engaged in a detailed stare decisis analysis. Ultimately, it decided not to overrule Roe, but rather to maintain its core holding. Dobbs overruled Roe and Casey on the matter of abortion rights, something that you all are probably well aware of. But Dobbs may have also overruled Casey on the matter of stare decisis itself. So Casey is well known as the decision about abortion, but it's also, in the legal world, probably the most well-known case about the doctrine of precedent, or stare decisis. So in that sense, it is or was a precedent about precedent. So in Casey, the court articulated a series of factors meant to guide its analysis of whether to overrule Roe. And these factors have been taken to be transubstantive, meaning that they apply not just to precedents about abortion, but to precedents concerning any area of law. In the majority opinion in Dobbs, Alito asserts, and this is the quote on the slide, that Casey deployed a novel version of the doctrine of stare decisis. This new doctrine did not account for the profound wrongness of the decision in Roe and placed great weight on an intangible form of reliance with little, if any, basis in prior case law. Alito, who wrote the majority opinion in Dobbs, supplants the stare decisis factors from Casey with a new set. So this set overlaps with the Casey factors, but it's also meaningfully different. And one of the main differences concerns the court's treatment of reliance interests. So on my reading, the Dobbs decision may represent a significant shift in the court's approach to precedent. It's unclear whether the court will now treat Dobbs as the prevailing precedent on precedent, but it wouldn't be surprising if it did, because the stare decisis analysis in Dobbs is very salient and again seemed to displace Casey's stare decisis analysis. So that would mean, and I'll explain this in more detail, it would mean that if Dobbs comes to be recognized as a precedent about precedent, it would mean that reliance is likely to play a relatively minor role in stare decisis analyses going forward, at least outside of the realm of cases concerning commercial matters like contract and property cases, where the court is more likely to perceive concrete reliance. Okay, so in Casey, sorry, I said it's from the 80s, it's actually from 1992. So Casey decided in 1992, about 20 years after Roe. So in Casey, the court reasoned that people were relying on Roe and that the reliance was important and widespread. But the court didn't say all that much about what this reliance consisted of. It said that in deciding whether to overrule Roe, we have to ask whether the limitation on state power could be removed without serious inequity to those who have relied upon it or significant damage to the stability of the society governed by it. And Roe's limitation on state power, of course, was limiting states' ability to ban or severely restrict abortion at least up to a certain point in pregnancy. Okay, so the Dobbs majority rejects Casey's approach to reliance interests. The court claims that only concrete reliance counts and not the kind of intangible reliance that the court invoked in Casey. Note that for the Dobbs court, it's not that reliance interests are outweighed by other factors that favor overruling. It's that there were no cognizable reliance interests here whatsoever to even be taken into account or to weigh in the balance. So how does the court justify its dismissal of reliance costs? It says a few things about this. So first, it says that there's no concrete reliance at issue here. And second, it suggests that although there are other conceivable kinds of reliance interests at play, those are irrelevant for the purposes of stare decisis. It mainly gives two reasons for this. One, because the court hasn't considered those interests in other cases, and two, because the court is not competent to assess those kinds of intangible interests. So on the first point, to count as concrete reliance, people would have had to take specific action in reliance on the precedent such that they would be worse off with the precedent overruled than they would have been had the precedent never existed at all. So this is a narrow conception of reliance. It's sometimes called detrimental reliance. It's the kind of reliance that people would have if they formed contracts or engaged in property transactions based on the precedent, and as a result had financial interests that would be upset if the court overruled the precedent. So from the point of view of the Dobbs court, in the abortion context, people would be worse off in that way. only if they became pregnant because they were less cautious in their sexual activity than they would have been in the absence of the court's recognition of the right to abortion. As soon as people learn that they no longer have a right to abortion, which presumably they would as soon as the Dobbs decision comes out, they can just be more careful to avoid pregnancy unless they wish to have a baby. So this is what Alito means, I think, when he writes in his majority opinion that reproductive planning could take virtually immediate account of any sudden ban on abortions. People could just update their behavior. So the Dobbs court determined that no or only very minimal tangible reliance was at stake in the abortion precedents. I think that that's incorrect. So even if we accept the court's narrow conception of reliance interests, such interests did exist here. So it's not only the people pregnant at the time of the Dobbs decision who might have relied in the concrete way on the right to access abortion. People have taken all kinds of other action, not directly related to sexual activity. So for example, regarding their educations, careers, relationships, and families in reliance on Roe. For instance, some people might have chosen to pursue their educations or careers in California instead of Texas if they had not relied on the abortion precedents. And now that access to abortion is extremely limited in Texas and adjacent states, they might be worse off than they would have been if they hadn't made decisions in reliance on the right to abortion to begin with. People might have also chosen certain types of demanding careers based on the expectation that abortion would be accessible to them, careers that depend on many years of uninterrupted education and employment to be successful. Some people might now wish that they had pursued different lines of work that are more compatible with unexpected pregnancy, childbirth, and parenting. People might also have made decisions about division of labor between partners based on the expectation that one who can become pregnant would be able to have an abortion if there was an unintended and unwanted pregnancy. People have also made immigration decisions to the US based on the expectation that the right to access abortion was constitutionally protected in the United States and that there would be a permanent or long-term right to access abortion. And healthcare professionals and others who have served abortion patients might have also relied on Roe and Casey to structure their affairs now to their detriment. One other kind of concrete reliance I want to note is that individuals may have relied on the abortion precedents in a concrete way in directing their political activity and voting behavior. So for example, some people may have seen no need to push for abortion rights at the state level because they were relying on federal constitutional protection for the right to abortion. And some states have old abortion bans on the books that were unenforceable under Roe, but have now apparently come back into effect. So for example, here in Wisconsin, where I'm located, we have a draconian abortion statute from 1849, which criminalizes the provision of abortion with an exception only to save the life of the pregnant person. And legislators may have made an effort to repeal those laws, and the public may have pushed for that if they hadn't been relying on the precedential status of Roe. Okay, so second, the Dobbs court suggests that although there may be other conceivable kinds of reliance interests at play aside from the concrete ones, those are irrelevant for the purposes of stare decisis. Why? Well, the court says that it hasn't considered them in other cases. That's just wrong as an empirical matter. I discuss this at much greater length in my article and give other examples, but the court has put weight on intangible reliance interests, not just in the case of Casey, but in various other cases. One example is the case of Dickerson versus United States. Here, the court considered the precedential status of Miranda v. Arizona. Miranda established the well-known rule that criminal suspects have a constitutional right to receive a warning about their right to remain silent, among other things. And in Dickerson, the court considered overruling Miranda, but decided not to. And one factor it took to weigh heavily against overruling was the society-wide reliance on the Miranda rule, that everyone knew about this rule and expected that we would have a right to the Miranda warnings going forward. That reliance can't reasonably be conceived as concrete in the narrow sense that the Dobbs court understands concrete reliance. But nevertheless, the reliance at stake counted in the Dickerson decision, and it counted significantly in the court's stare decisis analysis. Okay, two, the Dobbs court suggests that the court is not competent to assess intangible reliance interests. It's true that intangible reliance interests might be hard to assess with precision, but the court is ill-equipped to assess reliance costs generally, even the concrete kind, and maybe especially that kind. So the Supreme Court's not a fact-finding court. It's not hearing evidence, and the stare decisis analysis generally doesn't come up in any detail until the Supreme Court level. So it wouldn't have been argued fully at lower courts, the reason being that lower courts don't have the power to overturn Supreme Court precedent, only the Supreme Court does. And in past cases where the court was unsure whether people have actually relied on the precedent at issue, it has been more and not less reluctant to overrule just because people may have relied. So in other words, the court has given the benefit of the doubt to the side of reliance. If there's conceivable reliance interests, even if the court can't pinpoint it or measure it, it takes that to be a reason against overruling the case. And then further, the reason that reliance interests are hard to measure in this case when it comes to reliance on Roe and related precedents, it seems to be, at least in part, because these reliance interests are so widespread and multifarious. There are so many individuals, so many different groups of people that have relied on the right to access abortion, and in so many different ways. So it seems to me that there's a perversity of not counting costs at all when they take that kind of form, this diffuse society-wide form, as opposed to, for example, a discrete loss suffered by a specific industry that would come about because of a change in a property or contract rule. And that might be easier. It might be easier to identify the specific individuals and groups involved and exactly how much in economic terms is at stake. Okay, so turning to intangible reliance on the abortion precedents. So the Dobbs court, and this is the final point I'll discuss, and then I'll wrap up and we'll have time for Q&A. So the Dobbs court didn't take a stand on what it calls intangible reliance. It didn't take a stand on whether what it calls intangible reliance interests exist or not. It didn't have to, because it claimed that even if intangible reliance was present here, that kind of reliance doesn't matter for stare decisis purposes. So the court sees no responsibility to take it into account. Okay, so what is intangible reliance? As I understand it, the key difference conceptually between what the court calls intangible reliance and concrete reliance is that an individual might have intangibly relied on a precedent even if she didn't take any specific action based on that precedent that she wouldn't have taken otherwise. Whereas for concrete reliance, one would have to have taken such action and reliance on the precedent, and as a result now be worse off than if the precedent had never existed at all. So on my view, even when reliance on precedent is purely intangible, upsetting that reliance can undermine people's autonomy and offend their dignity, and courts have a responsibility to recognize and mitigate those harms. So many people have formed their beliefs and attitudes and intentions around the expectation that abortion would be protected nationwide under the Constitution. Thwarting the expectation that those beliefs, intentions, and so on are based on constitutes a harm that the court ought to take into consideration, even if there's no reliance of the kind that the court calls concrete. And again, I think there was concrete reliance here, but even if there wasn't, there was plenty of intangible reliance, and that should have mattered. So let's consider ways in which people were relying on Roe that did not meet the court's definition of concrete reliance. And there are more, but here are a few that come to my mind. So abortion figures into many people's life plans as a contingency. So they plan to have an abortion in case they unexpectedly and unwantedly become pregnant. They hope to never have an abortion, just like when we take out insurance, we hope to never have to file a claim. But it still does figure into our plans as a kind of contingency. And this is a way in which people were relying on Roe. The court's decision in Dobbs unravels this plan. This kind of reliance might exist even if people didn't take any specific action in reliance on Roe that they wouldn't have taken otherwise. It's clear, I think, that many people formed intentions and understandings based on the belief that Roe was a precedent and the expectation that the right to abortion would continue to be protected. For example, an individual might have made decisions regarding her career, relationships, and family life, like when to have children, all with the background expectation that if she became pregnant and wished to terminate the pregnancy, she could do so. And now that we no longer have a right to abortion, those decisions that the individual made years ago take on a different meaning than they had in the past, and then the individual reasonably expected them to have going forward. Some of the decisions she took might be riskier and just less desirable than she thought they would be. And now if this individual does become pregnant and has reason to obtain an abortion, she might not be able to follow through on her plans, which again were contingency plans. For example, she might have planned to get an abortion if she unintentionally became pregnant before completing her education or before establishing her career. And so after Dobbs, the decision, the individual, hypothetical individual here, doesn't have the life that she imagined and designed for herself in reliance on the court's decisions. And I think that's a significant setback to self-governance. And even if the individual is able ultimately to obtain an abortion, which isn't guaranteed, but some individuals, even in states with severe abortion bans, can still obtain an abortion elsewhere. There's nevertheless still a much greater cost associated with obtaining abortion, and there's more uncertainty around it than before, than when the right was protected by Supreme Court precedent. All right, second, Roe and related abortion precedents also created expectations of reproductive justice and gender equality. So people had the expectation that women and other people who can become pregnant would have the right to access abortion, which is a right that's critical to gender equality. And that expectation has been thwarted by the Dobbs decision, with deeply unsettling and disorienting effects for people who care about gender equality in this country. Then finally, another kind of intangible reliance that I think is worth mentioning is, it concerns systemic instability. So when a decision overturning a precedent might undermine the foundations of other precedents, the decision has ripple reliance costs because it upsets reliance interests in those other precedents too. So by overruling Roe and Casey, the court has upset reliance not only on the right that those decisions protected, but it's also disturbed society-wide reliance in other personal liberties, diminishing the benefit that we get from being able to rely on other judicially recognized constitutional rights, for example, to same-sex marriage and to contraception. And that seems to be the case here, with immediately a lot of attention from scholars and the media over the potential implications of this decision for other protected liberty rights. So when it overrules well-established precedent, the court might give rise to doubts and anxieties about the entire legal order, which seems to have happened here with the overruling of Roe. So should intangible reliance count for stare decisis purposes? So it's probably clear by now that I think it should. When precedents are overturned and expectations thwarted, it comes with costs to the kind of autonomy and dignity that stare decisis, when followed, serves to protect. And because people form their expectations because the court, in a sense, induced them to do so, it may be unfair for the court to frustrate those expectations. And all of this holds regardless of whether the reliance at issue is concrete. So with the overturning of Roe and Casey and many other related abortion decisions, the court forces us to abandon intentions, to change our attitudes, and to reimagine our identities and positions in society. Our careers, relationships, and lives are suddenly not what we thought they would be based on what the court had previously determined and declared. And the effect is destabilizing and disorienting because we're unable to carry out the lives that we had imagined for ourselves, and we're no longer living in the society that we thought we would get to live in. So to wrap up, Dobbs is a monumental decision about abortion rights. Everyone knows that. It might also prove to be a pivotal decision about stare decisis itself that has critical implications far beyond abortion. The court did claim that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. It had need to do that because it was pretty obvious that the decision would cast doubt on other precedents. And it's really hard to read the opinion as not casting doubt on other precedents. That's because of the opinion's approach to stare decisis, including its impoverished conception of reliance interests that I focused on here. All right, thank you, and I welcome your questions.
Okay, Nina, thank you very much. A very interesting presentation. I'm going to start it off with a question that asks you to comment on a phenomenon that I know exists within bioethics. So in bioethics, there's often a distinction that has to be made between one's personal moral beliefs and the right thing in terms of the framework of rights and duties that are present in the provider-patient relationship. So, for example, you might have an obligation to respect informed consent, and that might mean that you allow a patient to refuse an intervention, even though you think that intervention would be the right thing to pursue, right? And it strikes me that the sort of argument that you're making here is similar, in that it makes a distinction about reliance and predictability and the loss of this as being a problem regardless of one's own views on the morality of abortion itself or whether privacy is embedded within the U.S. Constitution. Do you agree with that characterization? And do you have any thoughts on that?
I agree with it to some extent, but I think that there are some important differences with the analogy. Because as I understand it, the principle of consent, which requires medical practitioners to defer to the patient's wishes, even if the practitioner thinks it's not in the patient's own interest, that's about autonomy more than about reliance. There might also be a reliance aspect because we know about that rule generally, even if we're not bioethics experts, people might come to rely on that and might be taken aback if the practitioner doesn't ask for informed consent. So there may be a reliance aspect there. Where I think the analogy is closer is on this principle that the individual should take their own personal opinion or preferences out of the equation. And that is part of stare decisis. So the idea is that present courts are supposed to defer to what has been decided previously, even if they might have decided differently themselves to begin with. And one reason for doing that is reliance interests that I focused on, protecting expectations. But there are others, like epistemic reasons, epistemic humility, not redeciding every single issue anew. But one other point I wanted to pick up on, it's a really interesting question, is the question of whether I think the question ended on the point of whether or not privacy and the right to privacy and the right to abortion is in the Constitution, or is like a real constitutional right or something like that. And this is getting much more theoretical than I got in the talk, but on my view of constitutional rights, those are not static. So it's not like we can just look at the constitutional text, and certainly not at one point in time, and say, if the constitutional right existed at the time that the 14th Amendment was created, it either existed or it didn't. And if it didn't, then there's no real constitutional right. Because I think constitutional rights are based in part on precedent. And that even though I think that Roe was correctly decided to begin with, even if it wasn't, so even if we didn't yet have a constitutional right then, it's possible that we do now, precisely because the court has recognized it, many other decisions have recognized it, and we have relied. So I see constitutional rights as evolving. So I would push back on that part of the premise of the question.
Great. Second question, and I'm combining some of these questions in these questions so that these reflect more than one question that's brought up in the Q&A. I wonder if you had any thoughts on what this decision means in terms of the politics of the Supreme Court, and for example, the politics of the confirmation process for justices, and the representations, for example, that are made by justices during their confirmation hearings, and whether or not these decisions are consistent with those representations, and whether or not the Supreme Court is more and more reflecting politics rather than legal interpretation.
Mm-hmm. So with the last bit, I do think that the Supreme Court seems to be reflecting politics and ideology, personal ideology, more than legal interpretation. About the confirmation hearings, there was a lot of attention to the fact that several of the justices who voted to overrule Roe had maintained a commitment to precedent in their confirmation hearings, including specifically to Roe. And I think attention was drawn to that for a couple of reasons. One, the duplicity, so calling out these judges individually, because it seemed problematic that they expressed a commitment to Roe's precedent and then were very quick to overturn it. And the second part was maybe people were actually relying on the statements that these nominees had made, including some senators. So that seems problematic. Now, I think it's a whole other question, and an interesting one, about to what extent that kind of reliance should be taken into account by the court. I actually think it shouldn't. I don't think that individual nominees get to make those kinds of claims and that then they should change how the court decides an issue. So some people would definitely disagree with me on that. But how do I think, just as a realism kind of question about how this will change how nominations in the future, I mean, I think people will put less weight on what nominees say. And maybe that's good, because I don't think that we should be relying on those kinds of statements, or statements of politicians promising to nominate certain people who will protect certain rights or who will be willing to overrule cases. So I think that there will be less trust in those kinds of statements.
Great. Do you think that this decision will lead to overturning a lot of other precedent cases? Do you think this is a trend that we should expect now, or do you think this will be a one-off in terms of the threat to precedents?
It's a dangerous question to answer, but something people always want to hear about. I'm hesitant to make any prediction. I think that the Dobbs decision gives the court a basis for overruling other decisions if it wants to. However, it might not want to. It might not even take a case where, for example, the right to contraception would come up. So even if we had a majority who would overrule the right to contraception if they heard the case, they might decide for many reasons, including perceptions of legitimacy, that it's not good to do so. But if they did take it, then I think, so my prediction after Dobbs versus before Dobbs is very different, right? Like, so I think that stare decisis is now much weaker, and in particular, reliance interests of the sort I discussed outside of property or contract cases. And generally these rights that we're talking about are outside of that area: contraception, same-sex marriage, etc. I think that previously, or a court that followed Casey on stare decisis would see reliance interests on those kinds of cases, whereas now I think the court may well not see it. So I know I'm ducking the question here. I don't know what the court will do, but after Dobbs, I'll be much less surprised to see more major overrulings.
We have an interesting question here about, in addition to pregnant people or people who can become pregnant, medical providers also rely on the ability to offer abortion services, especially, although not exclusively, in cases of medical necessity. So, for example, if the life of the woman is in danger. What do you think about those sorts of reliance interests as well, and the weight that they should carry in this? You know, the reliance of medical professionals to have this available in order to provide standard of care to their patients.
Yeah, I think that does matter. Those are a subset of reliance interests that I consider in the paper. And I think it's totally reasonable to think that healthcare providers have relied on the right to abortion and have been able to provide abortion with reassurance that they would be able to continue doing this. And they might have done so, taken up practice in certain states, like in Texas, with that expectation. And now their reliance has been completely upset, and they might have to rethink their practice, or even more broadly, like where they're practicing, what kind of medicine they're practicing, and so on.
We have a question here. It says, can you talk a little bit about what circumstances you think it would be appropriate to overturn a precedent? You mentioned that you aren't specifically against overturning precedent in all cases, and how it could be done in a way that wasn't violating the expectations of, that are embedded in this reliance interest.
Mm-hmm. So I do think that sometimes the court makes a serious mistake to begin with in interpreting the Constitution. An example is Plessy. So the court in Brown v. Board of Education overruled Plessy. Plessy protected the right of states to permit or even enforce racial segregation, and Brown declared that that was unconstitutional because it was racially discriminatory. And so there, I think it's such a blatant violation of equality under the Constitution that the court was right to overrule it. It would have been better if it happened even sooner. Some people have talked about, well, isn't there reliance on the Plessy case, that people had structured their lives around that? And that is something that the court took into consideration. I think that sometimes if the reliance is on something like a racist practice, then it shouldn't count at all in the analysis. And I actually think that might be implicitly what's going on in Dobbs, that at least some of the justices think that the practice of abortion and any reliance on it is morally evil or unconscionable, and that maybe that's the real reason that they didn't want to count reliance. So I think that would be one kind of case where overruling is justified and where reliance might not count for anything at all. I think I missed part of the question, though. Is there?
I think that covers my understanding of that question.
Okay.
The question here says, do you think the court should be more cautious about overriding a prior precedent when the reliance is based on expanding individual rights?
More cautious when it's, yes, I do think that. I discussed this in the paper, but I think that's exactly right, because I think that when we rely on personal liberty rights, many of these kinds of concerns like about autonomy and dignity come into play. Whereas reliance on, say, Dobbs, that restricts the right or gives the right to the states, that's really a state interest, that's being protected. It's not an individual right. So even though there's plausibly will be some reliance that builds up around Dobbs, I think that will have a very different character compared to the reliance on Roe, which expanded individual rights. I'm not the first person that has suggested this. Other people have made these same kinds of arguments about the direction that constitutional law should go.
And a final question here before we run out of time, sort of asked you for your personal opinion on something of theoretical, and that is the purpose of the Supreme Court. Do you think the purpose of the Supreme Court is to uphold the Constitution, or is it to help society to continue to evolve?
I think it's to help society to continue to evolve by upholding the Constitution.
Good answer. So, all right. I want to thank Nina for her time and willingness to participate in our bioethics grand rounds. I thank everybody for coming. Again, our next bioethics grand rounds will be held on May 31st. It will be on disability, inclusion, and access in both clinical medicine and in biomedical research. So please come and join us for that grand rounds as well. With that, I'm going to thank everyone and hope to see you in our next session.
Thanks very much for having me and for all the great questions.
Thank you for coming.